Ireland in Europe. Ireland is an EU member state, although that's less relevant here. It's a member of the Council of Europe and the ECHR. It's not a signatory to Oviedo. There are some of the obligations that Ireland facing. The international obligations, finally, after what feels like a very long time this year, last year now, Ireland ratified the UN Convention on the Rights of Persons with Disabilities. And it also has obligations under a number of other international treaties, such as the ICCPR and the Convention Against Torture. That button does not change, sorry. Oviedo is, the full title is the Convention for the Protection of Human Rights and Dignity of the Person, being with regard to the application of biology and medicine. So it's a Council of Europe Convention, so that's the ECHR. It is ratified by a majority of member states. It is signed by many more, and it's kind of a large framework convention with the idea of addressing a lot of issues in human rights and medicine and in bioethics. It was controversial. The UK felt it was overly restrictive and overly burdensome. Germany felt it was overly permissive, and I think that might reflect on certain attitudes that are being reflected in other issues, other European issues that we're currently facing. Ireland decided not to ratify or sign it at all, and is in the minority of nations that did so, although for other reasons that I will not get into because we don't have time. So Oviedo is rooted in the idea of human dignity. Actually, the phrase human dignity is referenced 3 times in the preamble. It purports not to create any new rights. The idea is that it is kind of framing existing human rights in a health context, and the rights that exist already there are already there in terms of like liberty in the ICCPR, or the right to life, or privacy, or prohibition against torture, things that already existed in various international instruments. But it wanted to frame it both in a European context and in a human rights and bioethics context. So again, it was a, sorry, I'm trying to manage 2 computers. So it was a framework convention, and it was designed initially to be expanded on. Again, as I may have already referenced, it deals with a number of massive issues. It deals with things like organ donation. It deals with things like organ donation. It deals with things like human cloning, which seems very far away from disability rights and research policy area. But it also is seen as a patient charter. And within that deals with issues of consent. So again, in the explanatory report, which was released a number of, actually quite around the same time in 1997, they said that, this is just basically rooting things in the concept of human dignity, that it constitutes the essential value to be upheld as the basis of most values emphasised in the convention there being the ECHR. And it was held as a framework convention, as the bioethics said, as to be the most realistic way to facilitate the long run, the development of common European standards in this field. So Oviedo did not purport to go out and answer all of the questions on all of the different medical and health and consent issues. Consent is the core issue in the convention, and actually the entirety of Chapter 2 deals with consent, and in a way, like in an explicit way that hadn't been with any other convention at that point. Basically, Chapter 2 in Article 5 says medical intervention can only be performed after the person concerned is given free and informed consent and be given appropriate information as to the purpose and nature of the intervention, as well as on its consequences and risks. Which sounds great, obviously, that seems like a standard thing that should be in medical practice and research practice, except it obviously went on to say that a person has to have the capacity to consent to an intervention and may not have the capacity because of a mental disability, a disease, or for similar reasons. So again, it was 1997, so that's actually like a while ago now. And at the time, we didn't have the same reference for, we didn't have the convention, we didn't have the CRPD, we didn't have the same standards that we have now. We hadn't gone through kind of the international disabled persons movement. We didn't have Article 12 or any of the good articles. It was kind of left there, and it also allowed for guardianship or representative or proxy decision makers, and that was kind of enshrined into the policy. This was in 1997. This obviously comes in direct conflict to. This obviously comes about in direct conflict to what became the Convention on the Rights of People with Disabilities. This was a convention that was negotiated by for disabled people, and as we've already talked about, was very strongly rooted in the idea of nothing about us without us. This was very much something that was extended to people's own bodies in what was a response to a history of forced treatment. And we began to develop under Article 12, like this idea of respect for will and preferences. And kind of throughout the convention, there's various things which kind of go directly against forced treatment, and by that go directly against Oviedo. You now have two conflicting sets of standards. You have the CRPD standard, which is which most which most Council of Europe states are obliged to. I think like 46 out of 47 states are obliged or have obligations or have ratified the CRPD. You then have Oviedo, which a large majority of the states have also ratified, and there's two conflicting standards. So there was then obviously a conflict. Now, to actually be fair to the Bioethics Committee at the Council of Europe, this conflict had already sort of come to light prior to the CRPD. In 2004, they published an explanatory memorandum which was to enhance the rights of people with disabilities, particularly in line with forced treatment, and recognising that, like what was in the convention that had been published 7 years earlier, things mightn't actually be in line with human rights norms. So they said that we were going to enhance it. Obviously, rather than actually enhance disabled people's rights under the convention, this ultimately led to the drafting of the optional protocol, or to the draft optional protocol, which goes directly against which goes directly against the values set out in the CRPD, and actually just embeds the same outdated values and permits forced treatment and seclusion and restraint in a number of settings, and it does this in a few ways. So the optional protocol is actually drafted very cleverly. It starts off with like great deference to the CRPDs, like we love it, it's great, disability rights, evolving standards of, evolving standards in human rights, and very much tries to embrace that. But then goes to basically say that forced treatment shall be allowed and shall be permissible, but only in restricted circumstances. So the text says it shall only be applied in conformity with the provisions set out in domestic law and in accordance with the safeguards established in the protocol. It says that it should be proportional and necessary and in the least restrictive environment possible. But ultimately does allow for forced treatment, which is not great. Again, it tries to basically restrict where forced treatment is used, and it tries to restrict where forced treatment is used, but ultimately continues to kind of endorse it. Okay. One of the also quite damaging things is it allows for seclusion and restraint in what is supposed to be a human rights instrument. So it says that it should always take place in an appropriate environment, but again, that seclusion and restraint should be allowed. It also stipulates that these practices may only be used with, again, the things proportionality and necessity, and placing time limits. But what it effectively does is it allows those human rights abuses to continue in more restricted settings. So the response was, as you can imagine, outrage. I don't think that there's any other way to describe it, but there's actually been, particularly across Europe, there's been a rather coordinated effort to challenge what has come out with Oviedo. And I think if you were to look at like organisations like Autism Europe and Inclusion Europe and Disability Rights Europe, like the pan-European NGOs and DPOs have been like particularly strong in saying this is a step in the wrong direction. That this is a step in the wrong direction. There's been some like quite biting commentary both from the committee, the CRPD committee, from the Special Rapporteur on Disability, and from the European Network of Human Rights institutions. You know, kind of a lot of highlighting that by going with it, by allowing forced treatment, that the draft optional protocol ultimately goes against the Oviedo idea of human dignity, that it's that we need to actually look towards the CRPD and look at methods that respect an individual's self-determination as opposed to a system-based enforced treatment. Catriona Vandas, who's the Special Rapporteur on Disability, said that it ignored a transcendental change in the way we approach the rights of persons with disability, which I think is possibly the polite way to put it. The CRPD committee also came out quite strongly against it as well. But ultimately, the draft optional protocol is still kind of hanging there. Oviedo still exists, and it leaves us in kind of a weird limbo, especially for the states that have ratified both instruments. States now have very competing obligations. They have the obligations set out under the UN Convention, but they also have the obligations set out under Oviedo. And again, sorry for butchering that name. It can go either direction. Most EU states are bound by both instruments. It means that Oviedo has the potential to influence policy instruments that might be seen as more local or a more direct responsibility, a more direct obligation. So it could influence policy instruments above the CRPD. It also has the potential to impact even in Ireland in terms of the fact that while Oviedo can't be directly challenged in the European Court of Human Rights, it can be challenged in conjunction with a violation of another article in the Convention. So yeah, that's basically where we are. The draft optional protocol is still there. There is a growing resistance. Bulgaria has come out against it. Which means Bulgaria won't ratify it. But if it was to push forward, each state would individually have the option of opting into what would be a more formalised mechanism for forced treatment. Ireland has ratified the CRPD and not ratified Oviedo, but it could still have influence, because if it influences ECHR jurisprudence, we're going to be bound by that. And yeah, that's basically it, so I'll leave it at that. Thank you.
Take the mouse. Sorry, I can't do anything without it.
Is the other one working?
Okay, next speaker up is Meredith Raley. She's from the Disability Federation Ireland, and she's going to talk about some of the DFI's research with local authorities around how to implement the Convention on the Rights of Persons with Disabilities.
All right, thank you. So a lot of the talks so far today have been about research with people with disabilities or about people with disabilities. So this is looking at the other side of it. This is research on how local authorities think about disability and about the CRPD. So the project I did was funded by the Irish Human Rights and Equality Commission under their Irish Human Rights and Equality Grant Scheme 2018. The goal of the project was to train up to 15 local authorities in how to use the CRPD as part of their public sector duty to respect human rights and equality. At the end of the project, we had trained staff at 14 different local authorities. And the training that was given it was free of charge, as it was grant funded. And it was given in 2 sessions. There was a pre-learning focus group to learn more about the local authority, so we could personalize the training to their issues, and also to give us a better idea of how local authority staff think about disability and disability rights. After the pre-learning session, they took part in a 4-hour training session on how to apply the CRPD to the work of the local authority. So the training focused on the CRPD in the context of the public sector duty. So for those of you, most of you, I imagine if you're here, you know what the CRPD is. But you might not know about the public sector duty. It's a bit newer and it's a bit less well known. So just quickly, it's a statutory duty. It's found in Section 42 of the Irish Human Rights and Equality Act 2014. It puts a statutory responsibility on all public bodies to take specific actions to eliminate discrimination, promote equality, and protect human rights. So they must have specific actions written out. They must have them in their strategic plan. They must yearly update how those actions have gone and how they're changing, what their actions will be. This is all monitored by IREC, the Irish Human Rights and Equality Commission. And the UNCRPD can provide guidance for public bodies on how to achieve these things in the context of people with disabilities. So the training focused on using the UNCRPD to achieve their obligations under the public sector duty. So these are the 14 local authorities that receive training, just so you know who they are. What you can see is we got a really good sample as far as we have some rural, some urban. They're scattered kind of all around the country, so we have all regions. So the findings we got as far as how local authorities think about disability and what issues they bring up should be generally applicable to all of Ireland. So how'd the training go? The results were by and large positive. It helped us gain a really good understanding of how the attendees, we had about over 14 local authorities, about 150 people attended, and we got a good understanding of how they viewed disability and what issues around disability concerned them. They were very engaged during the training. People weren't dismissive of ideas. They didn't dismiss the idea of disability rights. They really did engage with it and work with the CRPD. They were able to apply the CRPD very well, given prompting and training. Staff were very much able to look at the CRPD and look at their local authority and establish, okay, I can see barriers here, I can see solutions here. So any problems with human rights aren't really caused by a lack of understanding in staff. Given the appropriate training and the appropriate prompting, they are able to apply human rights standards to their own work. However, many groups were not optimistic about applying this outside of the training. They identified several obstacles to bringing their new understanding to practice outside of the training room. So we started off, a lot of what we talked about in the first session, the focus groups, were attitudes about disability. It's really interesting. So I'd start off every group by asking, what does the word disability bring to mind? It would be the first question every group would be asked. Like, what do you think of when you hear the word disability? Over half the groups responded physical disability immediately. Now most of them immediately corrected themselves and said, I know other disabilities exist, but it was always the first thing that came to their mind. It got to the point where it was, from my point of view, almost comical just how quickly that happened. For the groups that did not say physical disability immediately, they usually would say accessibility, barriers, inequality. So there was a difference there, but it's amazing how often that's where people jumped as soon as they thought of something. Generally, after people said physical disability, the disabilities they're most likely to talk about, that they would say, well, I know there are hidden disabilities, and they would almost always say ADHD and autism. Those are the first 2 hidden disabilities that people would think of in the group. And I should say those were almost always discussed in the context of children. People were much less likely to discuss autism and ADHD in the context of adults. In most groups, mental health and sensory disabilities also came up and were discussed in the context of their work. Intellectual disability was the least likely to come up and the least likely discussed when it did come up. So that gives you an idea of kind of the view of disability going on in a lot of these local authorities. So continuing that, so some groups, so to give you some of the negative news, some groups, less than half of the 14, did bring up the idea that people fake disabilities to claim services. Now, obviously, this is a really negative idea for local authority to hold because it particularly hurts people with invisible and hidden disabilities who will often find themselves not believed, distrusted, and challenged when they go to claim legitimate services. 2 local authorities, and only 2, said it's hard to find meaningful work for employees with disabilities. It's obviously also a real problem. It's fortunate it only came up twice, but it's surprising that they would have said it at all in the context of a disability rights training. So clearly there's work that needs to be done around those kinds of areas. No attendee ever mentioned a social model or medical model. They didn't discuss disability in that fashion. Some of them were, during the discussions, able to articulate something close to a social model, but they wouldn't use the word. This mostly suggests a lack of training in any kind of disability rights model or any kind of way of viewing disability through different paradigms or ideas. On the other hand, there were some positive findings. Attendees all agreed people with disabilities face barriers. I know that sounds like a really low bar for them to have cleared, but we have, but at DFI we have in the past done focus groups with the general non-disabled population, and they often won't even agree to that much. Often our findings with the general population in focus groups have been that they feel people with disabilities are well taken care of, and that they don't need anything, and why are we talking about their services? So all the local authorities at least cleared the bar of agreeing there are barriers. So it's a starting point. They agreed that public awareness of disability can be quite low, and that this can create its own problems for people with disabilities in navigating society. And many groups brought up the lack of resources for people with disabilities. They were aware that more resources were needed, that they could do more with more resources, and that this was a problem. So as far as the issues that groups identified around disability, there were obviously differences around the country, differences urban-rural, but some things came through in most groups. Almost every group brought up footpaths. Footpaths are an area that most groups can think of as being difficult to navigate. Almost all groups brought up disability parking spaces. Often there aren't enough of them, people parking them illegally. Some groups brought up the opposite, that the public has become so zealous in policing illegal parking, they're challenging people with hidden disabilities when they use the spots, and that creates its own problems. Housing came up a lot. Obviously, we're in a housing crisis. Housing is going to come up a lot. There aren't enough houses for people with disabilities, and housing adaptation grants came up in the same way. The backlog of housing adaptation grants, the fact that they can't provide as many as are needed. The expense of retrofitting, they said, is the most expensive thing they can do. And obviously, Ireland is a fairly old country. There's lots of retrofitting to be done. The lack of resources again came up again. They want to do more. They're aware they could do more, but the money just isn't there for them to do so. Employment for people with disabilities came up a lot. Obviously, local authorities are public sector bodies. They have to meet the 3% quota. 3% of their people in employment must be people with disabilities. And they also, and it's going up to 6% in a few years. So many of them are worried about how to meet that quota. If they're meeting it already, how do they meet the 6%? That came up several times. One that came up in almost every group and was almost always fairly passionate was mental health difficulties in service users. The staff feel that they are dealing with a lot of people with mental health difficulties. Obviously, they have no way of knowing if everyone who behaves oddly has mental health difficulty, but their feeling is that they're dealing with a lot of the people, and both that these people are not getting the services they need, and that the staff don't feel adequately trained to help to assist these people. So they feel like they're not delivering the best service, it's having an impact on them because they aren't trained, and that came up a lot during the discussion. So as far as how the training was received, as I said, the training was received almost uniformly positively. A few complaints here and there, but mostly people were very engaged with it and very interested in the training. Given the opportunity to brainstorm, participants were able to identify barriers in their local authority and suggest ways to address those barriers. So I've pulled out a few examples. I should say, we are writing a final report on this that will be public, so it'll have much more detailed findings. But a few examples, people suggested local authority offer accessibility awards for private businesses that would encourage the businesses to be more accessible and let people know which businesses were the most accessible. They suggested creating audio versions of documents, at least recording audio versions of summaries, so that could be on the website. They suggested asking about equality and human rights during planning permissions, asking people putting up buildings, what are your plans for equality and accessibility? Asking that in more detail than they had in the past. So they were engaged and able to think of ideas once prompted. It was just a matter of nobody had ever prompted this before. In addition, all groups talked about accessible consultations, the importance of involving people with disabilities in local authority decision-making, in any consultations or public hearings that they're holding. So as I said, the groups were not optimistic about being able to apply their training outside of the room once they left. They identified several obstacles. These obstacles also repeated. A lot of them were the same in almost every local authority. Lack of resources was a big one. It's like, yes, we'd like to do this, but the government's not going to give us the money to do this. Lack of buy-in from senior management. In some groups, I had a lot of senior management. In some groups, I had very little. In the groups with very little, the group worried that their managers would not listen to them when they came back with these ideas. Lack of support from the government. Again, that ties into lack of resources. And the lack of sanctions attached to the UNCRPD. It's really interesting. This is local authority staff, so they're government employees, and they're saying the government should be punished more for not following this. So it's an interesting idea that almost all of them said we need more punishment for the government for not obeying human rights when they're working for the government themselves. So post-training, we did 2 evaluations. They filled out an evaluation on the day of their initial response, and then 3 weeks after training, I sent them a survey asking what they'd experienced in the 3 weeks after. So these 2 questions are taken from the 3 weeks after survey. It had a response rate of a little over 25%, which is not bad as these things go. So 2 of the questions I've pulled out are, have you used any information or materials from the training since the training session? About 30% said that they had. Now obviously 100% would be great, but 30% still is a significant number who have directly used the training materials in their work. More positively, I asked, have you noticed any difference in your approach to your work since the training? 60% said they've changed their approach to their work based on the training. Now, maybe people who responded to the survey felt more positively about it, although I got 1 really negative response, so hard to know. But it's positive that people did feel differently about their work after receiving a simple 4-hour training session. And it suggests that there's a lot of scope here to train local authorities and civil service staff in human rights, and that they will respond to it. So yeah, my conclusions are that staff do respond positively to training around human rights and disability, and that it is a useful step to take. The most common benefit staff reported was more awareness of disability and disability rights, which suggests that awareness was that, plus the responses during the focus group, just awareness was quite low among the staff. Given the opportunity, people are more than willing to engage with these ideas, to apply them to their own work, and to think up solutions, even if they're less optimistic about applying those solutions in the real world. And yes, staff are positive about the UNCRPD, but do see obstacles to using it in their everyday lives. All right, thank you. And I have my contact details up there if you want to reach me later.
Our next speaker is Donna McNamara, who is an assistant professor in law at Dublin City University, and she is going to talk to us today around reforming the pre-trial criminal justice process in Ireland, a disability rights approach.
Everyone, thanks for the introduction, Catriona. I gave a version of this presentation in Galway here last year, and during that presentation I was perhaps a bit overly critical of the Garda Síochána. I perhaps pointed out a lot of flaws, so today I'm very much wary of the fact that it's been recorded and live streamed, so I won't be too negative today. And I'm going to look at some areas that we can improve upon. So looking at practical changes that we can make. As was mentioned, we have now ratified the CRPD just last year. So what does that mean now for criminal justice? Can the CRPD be applied within the criminal justice process? And my own research looks at it from the pre-trial process. So specifically, I am quite interested in the pre-trial process, and that requires looking at the police and looking at how people are engaged by the criminal justice process. Usually when people come into contact with the police, it's through the form of an arrest, but we know that there are issues, and there are similar issues for people with disabilities, whether you're coming into contact with the police formally because you've been arrested, but it can also be because you are a victim of crime and you just want to make a statement and report a crime that has been committed. And I know Robbie spoke about some of those issues today, but you could also be a witness, and there are issues regarding credibility there as well. So a lot of this touches on what we're talking about in regards to training. So my research looks at how we can train the Gardaí and how we can build a disability rights approach going forward. So in a lot of the research that you will look at in terms of when we think of the typical offender, and when you think about the typical offender in regards to people with disabilities, a lot of the time the research proves that people with mental health difficulties or conditions in particular are overrepresented in the criminal justice system. And that's across all stages of the criminal justice system. So that might be the pre-trial process, it could be the trial process itself, and then also in terms of imprisonment as well. So that tends to be the most common type that people think of. And that creates difficulties because they're often hidden disabilities. And if you think about the role of a police officer and you put yourself into their shoes for a moment, that could be quite difficult. So especially if you're on the street or you're effecting an arrest, it's usually a tense situation. It's usually, all individuals are vulnerable when they are being arrested. But if the police officer doesn't know that a person has a disability and then therefore might require extra accommodations, that can make their job harder. And there are situations, and there's a lot of studies regarding that in regards to just from the police officer's perspective themselves. So that also adds the need for training to make sure that they are trained to identify signs and symptoms of persons who may be in distress or who may need additional supports. There's also this debate that is triggered a lot in the research in regards to certain conditions are seen to be more dangerous than others. And there are certain hidden disabilities, like schizophrenia, for example, or psychosis, in which the police, if they're made aware of the fact that the person has that disability, well then they're going to respond more punitively to that individual. Such as, for example, using handcuffs where they may not have otherwise have used handcuffs in the first place. So there are things like that that we need to look out for that other people and non-disabled people might not have to worry about. But because you have a certain identity that is perhaps known to the police, that makes you more vulnerable in that situation. There are also other issues in regards to even just physical disabilities, which might be the easier case for the police to solve, because at least then you can see the disability. You can see if a person is in a wheelchair that they will need additional supports. If a person is blind, for example, if they have a service dog, I spoke to a lot of people and there was serious worries that if they were to be arrested, what would happen to their service dog? Would it just be left? And in a lot of cases, the worry would be that would be the case because no police station is equipped to deal with service dogs. And I learned a lot about that, particularly in America specifically, not really so much here. So it was interesting to hear Robbie's statistic earlier on in terms of the amount of people that use service dogs. But nonetheless, the issues are still important and we need to make sure that training is across all of those issues so that we're capturing everyone within that cohort. There's also the issue of dual diagnosis. So just because you have one identity, that doesn't mean that it's neat. So there's also, as we spoke about, disability is not a homogeneous experience. An individual could show up with lots of different identities, which can complicate the process even more. So there's approximately 8,000 people diagnosed with an intellectual disability and a psychosocial disability in Ireland. And that's something that, again, you need to think about the additional supports that are required for each individual diagnosis that an individual might have. There are also external factors that we must also recognise in terms of any study in criminology or in criminal law, or when you're talking about policing. It's important that we are aware of the other factors which can make one more vulnerable to come into contact with the police. So of course we've got race as a factor, socioeconomic factors are also important. We know that poorer areas are over-policed in particular, and all of that can make one, again, more vulnerable within the custody experience, just even in terms of being able to support a lawyer. So all of those issues are something that you must also be very much aware of. So in regards to the theme of this conference being disability and visibility, the area of transparency or the lack of transparency within this area of research was something that I repeatedly came up against during my PhD and frustrated me to no end. There is no clear data published in terms of how many people are arrested by An Garda Síochána every year. So there are numbers which suggest that there's approximately 20,000 people arrested every year, but there's no formal data released year on year by An Garda Síochána. There's no breakdown in terms of how many people might have a disability, how many people do not have a disability, how many are women, how many are men, etc., etc. So there's very little data available in terms of who we are policing and exactly who we are taking into our police stations. There's also very little information in regards to just the prevalence of disability within our criminal justice system anyway. So you see here some snapshots of studies that were conducted. You might note the years on those studies. They were all conducted quite a long time ago at this stage, and they were all small studies. So we can draw from them that there is a problem of overrepresentation, but they are quite limited, which again points to the need that we need more transparency, we need further research in this particular area in order to be able to understand what the scale of the problem is, how many people with disabilities are coming into contact with the police, not just as suspects of crime, but how many are going in to report crimes, how many are witnesses, etc. So greater transparency is needed, because then that might get An Garda Síochána to the table in terms of getting them engaged with training programs. Now, in terms of where the CRPD applies to this area, so Article 13 is the only provision in the Convention which mentions policing. So it specifically refers to the need for training as part of the overall right of access to justice for all persons with disabilities. And you can see there in Article 13.2 that mentions training for all persons working in the criminal justice sector, including police officers. Now, even though the CRPD doesn't really get into issues regarding criminal law, it doesn't set out your due process rights like other conventions or human rights texts might, we can still draw upon the other rights within the convention. So they're all general and they can be applicable within each individual context. So equality and non-discrimination, liberty and security of the person, right to accessible information, your right to dignity, those can all be applied within the criminal justice process, even though they don't specifically refer to your rights within the criminal justice setting. So in terms of making a case for disability-specific training for An Garda Síochána, so one of the main imperatives for including training is the fact that it is seen to be the best approach to combating stigma and negative attitudes which are held by the police officers. And this is recognised, as you'll see there, in the Office for the High Commissioner Human Rights Report in 2017. And there are lots of studies which show that without training, the police officer is more likely to respond more punitively than had they have received training. So there is a clear need for training, and particularly in training in mental health, those disabilities that maybe are not visible immediately. So being able to respond and being able to identify certain signs that a person might be more vulnerable is important. And then secondly, that issue of identification, it is a really important issue. The ability of an officer to be able to put in place reasonable accommodations is particularly important here to ensure compliance with the Convention. But we must note, it's not really the police officer's job to be able to identify and to be able to diagnose each individual condition that might appear before them. We know that this is extremely difficult. It can take quite a long time to receive a diagnosis. So to be able to do that on the street is quite a challenging ask. It's a tall ask to ask of police officers. And that is why I would argue we need a cross-collaborative approach. We need to be engaging with the experts, and we need to formalise access to individual services that can offer supports to the police in that area. So just looking at the training then that Gardaí do receive at the moment, so most of you might know that An Garda Síochána, the training college is down in Templemore, so it's a 2-year course, and as part of that, there's not very much information available in terms of what the curriculum sets out and the different elements of the training. But there is one module available, it's Policing with Communities, and that includes an emphasis on mental illness awareness, particularly in regards to the Mental Health Act of 2001. And as part of doing an assignment on that particular topic, our trainee Gardaí are asked to research these different conditions, so Alzheimer's, dementia, depression, bipolar disorder, anxiety, panic attacks, schizophrenia, etc. And they have to research those different conditions and the difficulties that would be faced by the police officer themselves if they came into contact with a person that were experiencing one of those conditions. So it's very much from the perspective perspective of the police, and there's very little emphasis on rights. From what I've gathered, there's no emphasis on the individual's rights, more so what does the Mental Health Act require, and then what the police officer's job in responding to that particular case would be. You've also got issues in regards to how you transport a person. All of that falls within that particular module. So last year I received the figures that there were 1,850 trainee Gardaí that had completed this module to date. That's out of approximately 14,000 Gardaí working in Ireland at the moment. There's no indication that that training will be made available to people who have already been fully passed out as guards, that are working as Gardaí for maybe 20 years. So there's no indication that similar training will be provided to them. Although I would argue now that we have ratified the CRPD, that is now essential. We need to be incorporating rights training within our policing services. There are very few cases, there's very little to point to in regards to the problems in policing in Ireland, and there's very little on the official record anyway. But one document that I can point to is this particular report that was published in 2015 by the Garda Ombudsman Commission. And if you can see that, you can even just see some of the language. So the Gardaí in question here, two arresting officers, took a person into custody who was homeless, who was known to be vulnerable to the Gardaí in question and had a psychosocial disability. And you can see just in terms of the language that the Gardaí used in talking to that individual, referring to them as a clown, being very, very aggressive in their tone to them. So this individual brought their case to the Garda Ombudsman, and the Garda Ombudsman said that this is very much, it represents the issues in regards to policing, and that there is a duty on police officers to ensure the human dignity and rights of all persons in detention. So this highlights some of the issues, and it highlighted the need for training and a rights-based training, emphasising the human dignity and the rights of all individuals. In 2009, there was a report commissioned on behalf of the Mental Health Commission and on Garda Síochána, and they emphasised the need for a collaborative response. So they emphasised the need for specialist supports to be put in place to enable or to assist the Gardaí and to enable the individual to be protected within the Garda station itself. No surprise, 2009, the recession, there was very few resources available, so nothing ever came of that. There was very few reforms made from that. So I would argue that we need to go back to the drawing board. Now that we've ratified, there is now a clear need to go back and see exactly what needs to be done. And one area is in regards to that identification and making sure that if a person has been taken into custody, they are showing signs that they are vulnerable, then there needs to be access and there are links between specialist services. And one of the things that really stood out to me when I was doing my research was the fact that we don't really have a formalised system of access to medical professionals within custody. And that was cited by the Committee for the Prevention Against Torture in 2014. They referenced the fact that there's no duty doctor rota scheme in Ireland, and as part of that then I followed up and asked a parliamentary question of the Minister for Justice, and this was the response I got a day before I submitted my PhD actually. It was that the Gardaí can avail of the on-call doctor service when they're dealing with people who are experiencing mental ill health. I would argue that there's no guarantee that every GP across the country would be aware. Maybe they may not be a psychologist or may not be trained to the same level. So that also creates difficulties. If we go back to the CPT report, they also said that just in general, Garda stations are not equipped appropriately and they don't have adequate medical facilities. They noted in particular one Dublin station, the examination room was totally unsuitable. And there's no guidelines in regards to information sharing amongst medical professionals. So if you had an individual who required, just 1 second, I finish this point. If you had an individual who was attended by two different doctors in the space that they were in custody, you might have a situation in which one doctor gives them medication or attends them, takes notes, but there's then no provision for those notes to be shared with the second doctor who comes into the station to treat them. So there's just a complete gap in the area in practice at the moment. We are trying to formalise the different arrangements, and the HSE are trying to put in place panels around the country, but those panels don't reference actual mental health specialists themselves. So there's a clear need to address these issues. There's a clear need to create links with the actual experts. And as part of that then, the whole theme of Nothing About Us Without Us, I argue that not just do we need access to services, but we also need to look at the lived experiences of people with disabilities who have been engaged with the police, who have gone through the system and have experience of reporting crimes, being arrested, etc., and bringing their voice to the table too, and redeveloping a training strategy which takes into account their experiences and their suggestions for reform going forward. So I know I'm out of time. If anyone has any questions, I'm happy to email a copy of the rest of the presentation, etc. Thank you.
Okay, our next speaker is Lorraine Lally, who is working with Epilepsy Ireland and is also a practicing barrister here in Ireland. And she is going to talk about reasonable accommodation. What does it mean for someone with a neurological condition? And as you can see here, she's going to talk to us via video link, so I hope that this works.
Welcome everyone to the conference today. I'm really sorry that I can't be there in person to greet you this morning and to talk to you. My presentation today is on reasonable accommodation and what does it mean in Irish law and in practice. This is an area that has always fascinated me from when I was a student, a first year doing constitutional law and learning about reasonable accommodation for the first time to now as someone practicing in the area. I find it's absolutely an amazing area. And the reason it's such an amazing area is because reasonable accommodation, if it was to be applied in practice, means that people with disabilities would actually be included in our workplace. So we'd have a more inclusive and fair society, really. And it is that kind of right to work, which is contained also in our constitution, which I think people forget about. The right to work and to be included is something that often people with disabilities have to fight for. It's something that doesn't come naturally if you have a disability, and reasonable accommodation can make that possible. When you look back to how the legislation was created, the legislative intent was for the whole area to be wide-ranging. There was a hope that there would be a clear duty to include people, that the legislative intent for people with disabilities would be that everyone would be covered, and it wouldn't make a difference if you had a physical disability, a mental health issue, or a neurological condition. So the difficulty is that for people in the area at the moment, it is not completely clear where reasonable accommodation begins and ends. And for those of us who have any sort of mental health condition or neurological condition, in particular, I look at epilepsy when I'm looking at reasonable accommodation for the purpose of the presentation. I'm looking at what we call hidden disabilities and whether or not we need to look at reforming the area or improving it. And so to begin with, I would say people often ask me, where does reasonable accommodation begin and end? The reality is that the Employment Equality Acts oblige employers to make reasonable accommodation for people with disabilities. An employer must take appropriate measures, that's the term, appropriate measures to meet the needs of disabled people in the workforce. The Irish Human Rights and Equality Commission, they divide it into 4 areas. And the reason they do this is because the legislation is quite old at this stage. It's more than 20 years old. And the difficulty is that for employers and employees, they're not quite sure where it begins and ends. But the 4 areas that they focus on are to have equal opportunities when applying for work, to be treated the same as co-workers, and to have equal opportunities for promotion and undertake training. So the first one there, to have equal opportunities to when applying for work. When you initially apply for work, very often it's an online application form you're filling in. And you will see that on the state, if you apply to any of the publicjobs.ie or the state jobs, they often ask you on the form actually, do you require any reasonable accommodation for the interview? This is not something you would see though, if you were to go to a private recruiter and you were going to work on one of the big companies, financial companies down along the quays in Dublin, you wouldn't see that little box there saying, do you require reasonable accommodation in the workplace? And that divide between public employers and private employers is also something that I'm going to look at today. But for people with a disability, they often say to me, what does my employer have to do? Or should I tell them at the interview? So the best thing to do is to begin kind of at the interview stage and look at what do you have to do when you're being interviewed. So do I disclose my disability? It's the most common question I get asked. Do I tell them? Do I not tell them? You know, to tell or not to tell is the biggest question. For somebody with epilepsy or a neurological condition, it's often worth getting legal advice. I tell a lot of people to get legal advice. I also tell them that at the interview stage, I would say that there isn't really an obligation to disclose it because there isn't an offer of a contract of employment at that point. And at that point, you're literally being assessed for the skills that they're looking for and the competencies they're looking for. And if you match all their competencies, the skills requirements, I don't see how it would be relevant at the interview stage. They make you an offer of employment and they send you a contract of employment. At that point, it would be worth possibly considering it. Is it to your benefit or not? Most contracts of employment have a probationary period, and this issue, this little term and condition causes problems for a lot of people with disabilities, because a recent example was a young man who undertook a job in Galway, and he was doing very well. The job was going excellent for him, and he was 3 months into it, perfect, everything's going fine. He decided himself, his own personal choice, his personal decision was to share his disability, his neurological condition, to share that with the employer and to share it with his co-workers. He thought it was only fair that they be aware and that maybe they could get some first aid training, they'd know what to do if something happened to him. He was really thinking about those he worked with, and it was out of kindness that he told them about it. But the problem is then, 2 months later, he got handed his P45, so 5 months into the job, he has now been dismissed. Does he have any recourse legally? No, they're within the probationary period, and he can't prove that it's because he disclosed, because the employer waited those 2 months. So the employer just said, listen, it's not working out. I wish you all the best. I've written a reference here for you. There you go. The reference is a glowing reference, which just adds to the confusion. And then he tells me, if it's because of my disability, it has to be. But then the difficulty is, under the law, what cover does he have? None. And he can't prove it. He can't prove it because he disclosed. But he said to me, as he put it himself, he's learned his lesson. He will be more careful in the future, and he won't be so quick to share. And I told him, at least wait until after the probationary period, because then you have some sort of cover or some sort of protection under the law. So it is an area that causes difficulty. The other issue is, who pays for reasonable accommodation? The taxpayers, the community, the employers, the employee. Who should pay for it? And this is a debate that is ongoing. There is state funding available to provide for accommodating a person in the workforce. The state funding is quite diverse. And the reason I say it's quite diverse is because the state funding covers, for example, different types of grants that you can apply for. Some of the grant funding is covered by the local authority. Some of it's covered by central government. Some of the other things that you can get, some other payments are provided through the social welfare department, and then other supports are provided through, ideally, the revenue system, where you can claim certain things back. So certain expenses or costs can be claimed back through the revenue process. But the uptake on all the schemes is extremely low. One scheme in particular, operated by the revenue last year, only had 3 applications. So there's a lack of knowledge in the area. People are not fully aware of their rights. The employers and the employees are not fully aware of what they're entitled to. And they're not entitled to they're not aware of what they can apply for either, or what's covered. In relation to who should fund it and who should pay for reasonable accommodation, there's also a debate and a discussion in relation to third level. So in relation to the education sector as well, the Higher Education Authority have said that they're not sure how long they can continue providing funding to the universities and how that's going to be mainstreamed and what could be done to assist it. You also have a situation in education and in employment where the people with disabilities often end up paying for the reasonable accommodation. The most common example I can think of is there was a student in NUIG with a visual impairment. She paid for the software for her computer herself because the delay with the university would have meant her not getting her thesis in on time. So she just couldn't be properly accommodated as it was in the university in Galway. So she paid for the software herself, and she will never get that money back. That was her own choice, instead of waiting for their process. The issue then as well, I suppose I've been asked about, is if you acquire the disability, during employment. And during employment is a different story altogether. If you acquire a disability during the time that you're employed, the law does protect you that bit more. You're past the probationary period. There's a potential for the unfair dismissals legislation to kick in as well. And also, there's issues there with the Health and Safety Authority can assist you. I know one person working for the HSE, and the Health and Safety Authority actually required the employer to make adjustments to the workplace to assist him. That they actually told them, if you don't make these adjustments, we're going to just shut off this floor. So if you don't create adequate workspace and stuff that's safe, the Health and Safety Authority seem to be a stronger entity in law to help some of these people with the reasonable accommodation than other state agencies. The debate always is, what approach should be taken. So you've got competing kind of needs and interests there. You've got the employer on one side, the employee, and then the other people in the workplace. So that competing needs that's there is a difficulty, and it is an issue. And the one issue you get asked by employers is, where does my legal obligation begin and end? Is my insurance going to cover this? That's the other issue that often gets asked with anyone with epilepsy, for example. Will they be insurable? Can I insure them? Is it possible for me to know that they're covered? So how does the current employment stuff protect someone or support them in the workplace? You have the Health and Safety Authority, but you also have the Health and Safety Welfare at Work legislation as well, which requires that people are entitled to a safe workspace, and that there is a role there for the employer to carry out assessments in the workplace, and also to engage, for example, occupational health experts as well to assist in making the workplace suitable for somebody with a disability, which again can be a very, very difficult thing to do in practice. So just moving on, the occupational health reports or the assessments of the individual's capacity is another issue that causes difficulty. There's a lack of guidelines in Ireland. So if an employer wants to get an employee assessed for their ability in the workplace, you have an employee and he's been there for 5 years and his situation changes. So he has a condition and it has evolved or something has happened as well. So he's an underlying condition and he's also, his disability has got worse or things have changed for him. That assessment of capacity, there needs to be more of a streamlined approach, or there needs to be some sort of objective guidelines brought in, because the lack of guidelines in Ireland means that, unlike the UK, we have no kind of national standard or approved guideline approach to this. And very often what happens is the assessment that's done, the capacity assessment or the occupational health assessment that's done, it's done by these companies in different places outside of the workplace. For example, one of the case studies I'm going to go on to in a minute, the assessment was done in Kildare, even though the person works in a hospital in Dublin. So he was taken out of where he normally works to do the assessment, which again makes no sense, because then the reports are very often biased, they're not fair, they're not objective, and it does cause difficulty then for the person with the disability. The question that many people ask is, what remedies are available? The options really are the Workplace Relations Commission, the Labour Court, and then at times, depending on how long you've been there, you might be able to bring a case to the Circuit Court under the equality legislation, or maybe the High Court on a point of law. Other avenues would be, for example, contract law. So if you have a contract of employment, there is a contract there are legal obligations there. Depending on the sector you work in, like the public services agreements and stuff, there's other protections there for people as well. I'm going to move on now to some of the case studies, because I think this is the area where you see the issues most, and I think is the easiest way to explain and see the practical difficulties for people, which is actually my main concern, to be honest. Case study 1 is Paul. So Paul works in a national hospital. Paul is a person who he had glasses his whole life, but after starting work in the hospital about 3 years in, his vision got worse. He now has a very serious visual impairment. He's been 18 years in the job now, and the hospital he works in are changing over their computer system. So what they have said is that they can no longer accommodate him. They can't actually permit him to continue working. He's been there for 18 years. He takes 2 buses every day to get there and 2 buses home. He loves his job. He loves the work. He loves just going in. He loves doing it. He works part-time. He only does 18 hours a week, but he adores the job. he got his trade union representative involved, hoping that he could get an alternative role or a different role, maybe an admin role, or he could retrain. He was willing to retrain. He was willing to do anything they wanted to continue working in the hospital. He loves working there. It's like his family. It's his community. So anyway, the trade union representative didn't keep any notes on the meetings with the hospital, but everything was done over the phone, as it always is in the HSE. Everything is over the phone, so you can't get anything in writing very often. But the trade union guy had actually negotiated for the employee a settlement of 87,000, and he got very upset about this, because this is not what he told him. He told him, I want to retrain, I want to upskill, I want to continue working. Paul is in his early 50s. He doesn't want money. He doesn't want a payment like that. He wants to continue working. He wants to continue working for his physical health, his mental health, everything. He has no desire to take that money and accept it. If he did take that money, for example, he would have to pay tax on it. He would probably lose his medical card. It would have devastating effects for him. So he got quite upset, and then he went to see a solicitor, and instead he went down the legal route, and we did get a solution for Paul through mediation, where he's now been retrained in a new role, and he's now doing the phones and stuff in the hospital. So he's doing really well. But that initial treatment by the trade union representative, he thought he was helping, but he wasn't. And he didn't understand the complexities either of the condition or the difficulties for the client. The insurance issues are always there, and the health and safety issues, but we would submit that it really has to be what the person wants. So in the end, he did get what he wanted. He did get retrained. He did get upskilled. He's working on the phones, and he's also working on the new accounting package that they have. So they have a new accounting software package. He's entering data into that using the software that they have purchased for him. So he's doing quite well. Case study number 2 is Mary. She was involved in a professional role for a very big kind of stock brokerage firm on the Keys, and she basically is working from home as well. There were supports in the office, and she was using the resources, but Mary's difficulties were mainly mental health issues that developed in her late 20s, early 30s, and because of that, she passed the probationary period. There were some contractual issues, and then for resolution of it, we did end up going to the Workplace Relations Commission, and the employer in the end reached a settlement with her instead of her going back, because she felt she couldn't. She felt like everyone was talking about it. There was an issue of victimisation and bullying as well, because her line manager disclosed her condition to other people and actually CC'd about 8 people on emails and stuff. So Mary felt that it wasn't possible for her to return to that role, that she had been damaged and that it wasn't a viable option. So she's now moved on, and she's got a new job somewhere else, and it is working out for her very well. So it's not always possible to stay where you are. And in Mary's case, the stigma around mental health is so severe that although she had another condition as well, on top of it, she had lupus as well as the mental health issues. There didn't seem to be the same focus. Once they knew about the mental health issues, they weren't that as supportive as they could have been. Even though Mary was working from home, half of her time was working from home. So they weren't really willing to accommodate her once they knew about the mental health issues and the difficulties she was having. And the fact that it was shared inappropriately and that her right to privacy had been so breached was deeply hurtful for her. Okay, you're fine. I'm just going to wrap up by just thanking you all for coming today, and to say to you that good luck with the work. And I would say that if you can, try and educate as many people as you can about reasonable accommodation, and possibly look at ways that we can improve the legislation through statutory instruments and other supports. The reality is that we don't have reasonable accommodation in Ireland. And for those of you who are in the university, as somebody who did work with disability student services in the university as well as a student, they would have said the same thing. The reasonable accommodation, where it begins and ends, is quite difficult. We need guidelines, we need supports, and we need as much advocacy as we can get. We also need the government to try and look at how it's dealing with it, because there would seem to be money there, but it is not being used, or it's not being applied for. It's been used ineffectively. So I would thank you all for listening, and I'm going to send on the presentation and the paper after today, and I hope you have a really lovely day at the conference.
Okay, so I just want to thank all of our speakers on the panel today who have looked at a number of different topics across forced treatment and coercion, to the public sector duty in local authorities, to the pre-trial criminal justice process, and lastly Lorraine's conversation around reasonable accommodation. And I want to open the floor up to any questions, since we only have a short time now.